Okay, starting with who I am, I want to start with a little bit of my own resume, not to pat myself on the back, but to make it clear that I have the ability to make the determinations that I've made. And quite frankly, I am better positioned to make the judgments I've made than your district attorney is, and I disagree with her. But the city cannot allow the council to believe, as Ms. Tam said yet again tonight, that she's been cleared by a vigorous investigation by the DA. There was no investigation by the DA. The DA read my letters and decided, for reasons that escape me, not to do justice in this case. We can and we will continue trying to persuade the district attorney to do justice here. We never got to see her respond to Mr. Kecker's August 12th letter rebutting mine. The fact that there's a letter from her very talented Yale-educated lawyer that never got responded to or rebutted by our side of the case may explain the district attorney's error. But I do want to make clear the district attorney did get it wrong. She swallowed whole an argument from Mr. Kecker that is simply wrong. As I said, the Alameda Charter provides no process for removing a council member for misconduct, although they do lose their office if a court convicts them of a felony. Thus, the remedy for Ms. Tam's misconduct, because no felony has been proven, is a civil lawsuit under Government Code Section 3060, which only the DA can bring and only after the grand jury requests it. Ms. O'Malley is refusing to allow the grand jury to even look at the evidence. She's claiming that the case of Steiner versus Superior Court prevents her from doing so. With all due respect to your recently elected district attorney, this is simply wrong.
I presumed you informed the district attorney that you do not believe they did a very thorough job. You do not believe that they have reviewed your information because they disagreed with you.
I sent a letter on the first business day after I received their letter, copied to your attorney, which I assume that you have seen, requesting an opportunity to review your lawyer's last letter and indicating that we intended to respond to it. I assume you're aware of the contents of that letter.
Okay.
I just have a quick question. For the second or third time tonight, you made the comment that the district attorney did not conduct an investigation.
Indeed. Her letter said she refused to conduct an investigation.
Have you read it?
Wait.
Trust me, I've read it.
No, okay, maybe I'm confused because they said they thoroughly reviewed your submissions and you expected, I'm not clear what you were expecting. You were expecting them to come down to City Hall and do what? Gather evidence. It's rather basic. It's what district attorneys do. But didn't you present evidence?
Some evidence that, in my judgment, was enough to get to a conclusion, but certainly enough to justify an inquiry. We didn't get an inquiry. They shut it down at the outset.
Why would this DA get this thing so wrong, under your opinion?
I don't want to psychoanalyze your district attorney, but I can make a couple observations. First, we're not primarily dealing with criminal law. This has nothing to do with a mugging. It has nothing to do with a murder. It has nothing to do with a weapon. This is civil law, and it's the civil law that applies to local elected officials that I have spent 20 years practicing and that Ms. O'Malley has never practiced. So she's off her turf, so to speak. Secondly, I get to go home tonight, and I don't live in your community, and I don't have to run for election anywhere. Ms. O'Malley lives in your community and has to run for early election here, and I'm sure she and her staff would love nothing better than if you had a removal from office provision that didn't put them in the middle.